Okay. Well, welcome this evening. You are here. We're going to be talking about young families needing savvy estate planning. And yes, we do. My name is Tasha John. I'm an attorney with Cunningham Legal, and I'm joined by Jim Cunningham, who is the founder of our firm. I'm going to move forward. That is actually a picture of my family. So I am a young family. I've got 3 little ones myself. So a great topic for all of you out there that are either interested in this or have a young family yourself. We're going to hit some great topics for you. I'm going to go forward with saying that we are attorneys here today. And because of that, you're going to learn all kinds of great information, but this is not legal advice. We will give you an opportunity to meet with us, call in, make an appointment, have a consultation. And when we meet with you one-on-one, that's going to be legal advice because it's particular to you. A little bit of housekeeping here as we go along. You'll notice that you are muted and we can't see you. But if you have any questions as we go along, there's a question and answer tab up there in Zoom. Go ahead and type them in, and Jim's really good at keeping his eye out for that. So he's going to go ahead. We're going to try to answer as we proceed. We're going to try to move around fairly quickly. So if we don't get to your question, we'll be sure at the end that we leave some time to address any of the questions that you have. All right, so I want to talk about young families in general and why I think that they have kind of neglected planning at this point. They've got young children, their lives are kind of overwhelmed. Maybe that first child was born and they thought, you know, I probably should do something about that estate plan. That tends to be the first time it clicks for them, but now their kids are in sports, they're super busy, they have jobs, they're both working, possibly even caretaking for their own parents, right? So have a lot of stuff going on in their life where kind of the last thing they've been thinking about maybe over the last couple of years was, I really need to get a plan in place. I haven't thought about that for a while. So, you know, the #1 cause of young families not planning, procrastination. Yeah, so if you're here with me today, maybe that's you. You're just kind of looking to get started as a young family and know that you've put it off too long. And, you know, with everything going on in the world and COVID-19, you know, it's been top of your mind, and it should be. And we're going to talk about why it's so important to put in place a plan for you. All right, so I want to introduce you to kind of a sample family of ours, some clients of ours. And we're going to go through a couple things that they're going to have to think about being a young family and some of the decisions they're going to have to make when it comes to estate planning. And there is kind of a misperception out there that estate planning means you have to be like a multimillionaire, like I've got to have an estate, right? That's not true. It's very little actually that you need to do some planning. So meet Doris and Chris. This is some of our clients that have come in to meet with us, and they don't currently have a plan. So if this is you, a very similar situation. They have minor children. You can see that one of their main concerns is one of their children is a child with special needs. They want to make sure that they can address that and make sure they maintain public benefits so those are available for that child. We're talking a lot about guardianship here today because it's a really important aspect for our younger families, thinking about who's going to be caretaking for our loved ones and controlling their assets if as parents, you know, we're no longer able to do that. And so I'm going to start off just with that topic because I think that hits young families really hard, the importance of a guardianship, whether it's going to be your parent, okay, or maybe a brother for them that they might be choosing going forward. And there's going to be a lot of things you have to think about, but I want to kind of give a distinction here. There is a difference between guardianship of the person, right, of the actual person and caretaking for that loved one versus guardian of the estate, which is the finances. So controlling the money for them. And what we, you know, first are going to start with is guardianship of the person. This is what we don't want, okay? Fighting among our loved ones, whether it's our siblings or our parent with a sister or our friends that step in and think they're the best person to step in and take guardianship, or quite honestly, it could be an ex-spouse. Maybe you've remarried and they don't have custody of the child and they're stepping in. So a lot of considerations in here about who has the power at this point over the children, right? If you pass away and they're still minors. So let's discuss first, you know, what is the law regarding that? And what happens if you actually were to pass away? How do we get someone to step forward? You have to file with a court a petition for guardianship in the county in which that minor is living in when you pass away. And sometimes we usually also file what's called an ex parte temporary guardianship. So do it really quickly, get someone in right away. In the meantime, while the court's kind of deciding who's going to be the actual guardian when we go through the court process. It's like an emergency filing, right? We want to make sure in the meantime we've got an emergency person set in place that that can take care of that child. Then will there be a fight, right? I mean, what kind of battles are going to happen at this point? And don't you want to say in that? Don't you want to say in who's going to be that person to step forward and take care of that child? Now, it really matters, you know, to the court. Essentially, what they take into consideration is, of course, what is best for the child. They really want to consider what, you know, location, who's stepped in right away to help caretake for that child, who's been a big part of their life. Maybe it's really hard, though, for the court to know that. Even more important, why you have to put your wishes in writing. You've got to fill out some guardianship documents discussing who it is you would nominate for the court to choose as the guardian of that child. Got to make it really clear. I'm going to give some examples of some of the things that I've seen with clients, that is just a really good example of why you have to be very careful in these guardianship documents. And we do draft separate guardianship documents to make it very specific, and it's really a good reason for that. One example is I had a client that remarried, so a lot of blended families, and they were divorced. And the ex-husband of my child, let's just say, not a really great person, okay, hasn't really been involved in the child's life, has chosen to have no custody rights. So 100% custody went to the wife. And she's in this new, you know, marriage, and they've been married for, you know, quite a number of years at this point. Now, if she passes away, and think about this, if she passes away, who do you think has first rights to become guardian of that child? It's that ex-spouse, all right? That's an automatic legal right because they're the father, right? He's the father. And it could be, there's some things that, you know, that father has exposed that child to, has no relationship with, maybe something worse than that we have to make sure for the benefit of the child, we're keeping them away from that ex-spouse. So in those circumstances, and for my client, we made it really clear in her guardianship documents, because believe me, even though it's a legal right for that ex-spouse to step in and take that guardianship role, the judge cares, right? The court's going to care who ends up with that child and want to make sure they're in the best place. So if that guardianship document is very clear that she would like that child to be with the new spouse, or maybe a sister or a parent, and specifically mentions that it is in no way to be the other parent, okay? And in a lot of circumstances, I'll mention the court case numbers, okay? And like what the circumstances were, and that he never had custody of that child and has been estranged from that child. So put enough facts in there for the court to kind of look at and consider, because again, that parent has first rights on that child to step in and be able to control the guardianship of that. And so placed into that reason, there's got to be a really good compelling reason for the judge to go a different way. So you got to be compelling in your documents in these considerations. All right, what about challenges associated with your choice? So I get a lot of questions about naming guardians that perhaps live in a different state or in a different country. All right, so let's first talk about a different country, because that's a big one. Many of my clients are here, but most of their family is in Canada, India, and they're all over the world. And they come in saying, I'd really like my child, you know, to go to this relative over in another country. I will tell you, there's no automatic prohibition on that. There's nothing that says you can't name that person. But do you think that the court's going to be willing to do that? Because what happens is they don't have jurisdiction over that person. They have no oversight over someone that's out of the country. I would say it's very unlikely, Jim, I don't know if you agree, that a judge is going to see that as being something they want to do. No oversight, well, right?
Yeah, you know, and here's, I think you correctly identify the problem is judges, you know, when a person names a guardian, you technically don't name a guardian, you nominate a guardian. And there is a court proceeding before guardianship is granted where there's a background check on the individual guardian, you know, whether it's a guardian of the person or a guardian of the estate. The guardian of the person, by the way, is the one who signs the permission slip where it says, you know, at a sports signed by the parent or guardian, that's a guardian of the person. The guardian of the estate holds the money. Now, I can tell you that every judge that I know really wants to do the right thing. And I think it is highly problematic if you have minor children, and this frankly comes up a lot with clients who have emigrated from India, as well as from other countries, but primarily India. Well, India and Britain is where we get a lot of our immigrant, recent immigrants to the United States. That minor child's life is in the United States. And so, grandma may be back in the country where the parents came from, but that child's friends, their social network is in the United States, and a judge is going to be very reluctant to disrupt that. And there are also treaties that govern where children go. So if the parents live in Syria, for example, there is no way a judge is going to let a child go to Syria. India, maybe. Britain, yeah, more likely. But it really depends on if these individual countries have signed various treaties.
Right. And it's not, if you end up choosing somebody that maybe lives first, like out of the country, and you said, absolutely, I want this person to have first choice, recommendation would be make sure you have a second on there that's somebody in the country, because they are most likely going to be the best backup. So you got to think in the short term, who's that backup going to be? Also, right, if somebody you're nominating is in a different state or a different country and they can't get here quickly, all right, you might want to, in your guardianship documents, be nominating a temporary guardian during that time period, right? So make sure you say, I'm nominating this person until the time point that you can get to the location and be appointed by the judge. This is my temporary person who's local. Maybe it's a friend that lives close by, like that's my case, right? You would probably make sure your documents, you're nominating that more close in contact person. So really a lot of decisions have to be made on this.
Naming someone out of state also is administratively slightly more complex, because Tasha, as you said, you do name that temporary guardian or a permanent guardian, and then you have to start another guardianship in another state and then transfer that guardianship and then close the guardianship in California. So it's a pretty complex maneuver. And frankly, when you're talking minor children, by the way, if a children has a parent, as you said, there is no need for a guardianship of the person. But even if the parents are both alive, if the minor child receives more than $5,000, so if the grandparents want to leave $10,000 to the grandkid, you have to open a guardianship of the estate. So that is a very important consideration. Guardianships are very expensive. They typically run about $7,500 to $15,000 in the first couple of years. That's the total fees that are involved. So you want to make sure and consider that when you do your estate plan.
Right. And all these considerations really you need to express those to your attorney you're working with, make sure they're a qualified attorney, and make sure they know some of your concerns. Like I would like it to be someone local who, could probably stay in the same environment for my kids, go to the same schools. If that means my brother won't move to this area, that's a huge consideration for me. I would like it dropped to this person, right? I mean, there's going to be a lot of things you have to consider.
Yeah, and another consideration, by the way, is age. So age of the minor. And I'll tell you a quick story. When my son was in high school, he had a friend whose mother had passed away when he was a kid, a little kid. And then when his friend was in 10th grade, his father passed away. And the father had named guardians in a different state. But, a 10th grader is 15, 16 years old. A court is really going to listen to a 15 or a 16-year-old. What ended up happening, and it was completely amicable, there was no fight over it. What ended up happening is the guy who was in 10th grade, my son's friend, ended up living with another friend's parents, and they became the guardian. So age is also, obviously if the child's 2 years old, there's not going to be any meaningful participation. And it is a sliding scale the older you get. And under sort of ancient English law, it was 0 to 7, 7 to 14, and 14 to 21. So once you hit about 14, that's when a court really is going to listen to that minor.
Mm-hmm. Yeah, and one of those benefits of getting that guardianship established is they get health care. And so that's a big push. Sometimes kids are 17 and they're like, oh, we'll just wait, not do the guardianship, and let them hit that 18-year-old age. Well, you kind of missed your opportunity for them to be on the health care of somebody else. So again, all those things, if someone's passed away, get on the phone with an attorney. I mean, someone's got to contact someone to make sure you've got things going in the right direction. Okay, so This has everything to do with taking care of the person, and that can be different, right, than who you want controlling the finances. It could be the same person. But I'm going to go forward to guardianship over the estate. Again, we're talking about money and who's going to be controlling it. I'm going to go back to my example of the client that got divorced and remarried. Now, although he had an automatic right when it came to guardianship over the person, he does not have an automatic right when it comes to guardianship over the estate. And the great thing about this is you can avoid this entirely. You don't have to go to court to control this. You just have to have a really good estate plan, right? Because ideally, everything should be going through your trust and controlled through everything you've said in your trust. You shouldn't have to go to court to establish who's controlling the money. And Jim gave a great example, though, of sometimes when that happens, you know, an inheritance from someone else, and then you have to end up going through that. And boy, what a burden. But so making sure you have something in place is really important. Okay. And, you know, I will say too, if you had no plan, if you have no estate plan and this has to occur, someone has to go to court and, you know, they have to establish who's controlling the money. Sometimes it's not the money that comes to your children. Sometimes it's not the percentage you think it is, right? If you haven't done a proper plan, I have an example of a client where the husband passed away very suddenly, very unexpectedly. And it turned out the home that they shared together, he only had titled in his name, okay? Which is technically, it's separate property, is something that we'll talk about a little bit later. It was only titled in his name. And so technically, according to the law, okay, a third of that, they had 3 children together. A third of that went to the spouse. 2/3 went to those kids. Okay, they actually had a share in that, and they had to go to court now to establish a guardianship over that 2/3 of that home that, you know, he shared with his spouse. But guess what? She didn't get it. You know, that's not the way the law works. So just really important that, you know, we'll talk a little bit about the character of property, but boy, you got to avoid this. You got to have a really good plan and say where things go and who's going to control it, because now we have a court deciding that. We're spending all this money going to court, setting up these guardianships, and now we've got oversight from a court and accountings, and boy, it's really burdensome. So really important to avoid this. All right, how do you avoid this? Well, one of the reasons, so we'll talk about that family that I initially introduced you to. They have those 2 daughters and again, 2 minor children, and in their estate right now, they own a home. They own it together jointly, and they have some bank accounts, brokerage accounts, some life insurance, pretty large life insurance policies. We'll talk about those. My younger families, and typically they do have, I mean, right, you're planning for what happens. If something happens to me, I want to make sure my spouse is set up and the mortgage is paid off or whatever is needed for them. So big life insurance policies, and they have the retirement plans. I would say overall, their estate value is around $1 million. Okay, so in your mind, you're not thinking they're not billionaires, okay, but they have to plan. What happens if they do nothing with that size of the estate? The state has a plan for them, right? It's called probate. So if you don't have a plan and you very minimal requirements in California for you to end up in a probate proceeding, you just have to own real property, right? It could be dirt. It could be the bank owns it all, right? You have a large mortgage. It doesn't matter. We put that as a priority in California. So if you own real property, that's going to be a qualifier. There's also an amount of money that is a qualifier in California. So if essentially anything is over $166,000, then it's going to end up in a probate. So we really value that. So it is going to have to go through probate. They're at that mark, right? If they were to pass away and they own a home and they have all these assets out there, millions of dollars paying out in a life insurance policy, they're going through a full probate. That's a court proceeding. If you could imagine, why is that so bad for an estate to go through a probate? It's because it's really expensive. I mean, you can imagine this is why people do estate planning, right? So in $1 million estate, I mean, you're looking at $50,000 or so out the door to just get this set up, let alone the guardianships and everything else that has to occur. So that it really just adds up. Also, probates are typically taking, I mean, they used to take around 16 months to go through, so nothing's distributed. I want you to think about that for a second. And now think COVID. So the courts closed down for months and months and months, all right? They are so behind, and they were not hearing probates. And, you know, there was no way for them to really even allow people control during that time period when people passed away. So I can imagine in California right now, probates are going to take a whole lot longer than 16 months with what?
Yeah, and I'm glad you mentioned that, Tasha. It's a disaster. We have several probates that we had to delay filing. And some of these, one of them was a $10 million estate. And so with a lot of rental properties, and when you've got an estate of that size, you really need to get on it and get things done. And we literally had like a 3-month delay. It was terrible. So the client came in just as COVID broke and the courts were closed.
Yeah.
So not only is it bad, but it does require a court. And going forward, who knows? If we can conquer COVID with a vaccine or more vaccines, plural, then we might not have these court closures. The other thing that happens when the court closed is they pushed out all the civil matters, and that would include probate, because they have to handle the criminal matters first. So it's been a real disaster. It has not got much press in California, the consequences of the courts being closed, but it's a serious problem right now.
Yeah, no, great effect. So the solution for that, right? You clearly understand now you have to avoid probate, going to court, avoiding the court being involved with the guardianships and the guardianship of the estate. How you avoid it is you create something called a trust, right? So a trust, in California, we're community property state. So when these clients came to me, we're creating just one trust. It's a joint trust. And they're the creators of that trust, the husband and the wife. They create it, and during their lifetime, they're also called what's the trustee. They're the manager of their assets. Nothing's really changed. They have full control over those assets. They can still, pull it out, buy it, whatever they want to do. But it's really important for them to retitle their assets into their name of their trust, right? That the house has been moved over to the name to the trust, and we have everything designated properly over to that trust, because ultimately, if something did happen to them, it's going to their children. And we'll talk a little bit about that. So this trust is not a separate entity, okay? It is still their social security number. It is not for asset protection. We do a lot of asset protection using other devices. That's not what this is for. It's to take care of you during incapacity. If something happens to you, put the right people in charge to say who gets what and how they get it, and make sure we have all the protection in place. But if you need asset protection, you can talk to us about that, but it's a very different structure that you're looking for. And so this is the solution to avoid probate, get everything taken care of. One of the main decisions you're going to be making is who's going to be your trustee. Now, initially it's you, and if something happens to you, it's going to be your spouse. It drops down. So whoever the survivor is. But if something happens to both of you and you do have minor children, who's going to step in now and control your assets for their benefit? Their dependents on you. And so at that point, the trustee has to, steps in, and they have to use that money to help your dependents and make sure the bills are paid and that they're getting what they are provided for, and they're controlling the money, okay, the assets. You have lots of choices when it comes to trustee. You can absolutely be a family member or a friend. Obviously, your children are too young right now, so they're not going to be able to do that. And so we have to think a lot about what age would be appropriate for them to do that. And that's something you should talk to your attorney about. But it could be a family member, it could be a friend. I have many people that might name their parents as the guardian of the child, but they really don't want their parents handling any of this money if something was to happen to them. So they have like a brother or a friend that's close by, someone who's really fiscally responsible, right? Because they control your money and no one's overseeing them. It's the great thing about a trust. The court is not involved. So, if they're the ones that are controlling the money, who's watching them or knowing whether they're taking some of that money and putting it in their own pocket?
Nobody.
Yeah, nobody's watching. It's bad. It's illegal, but who's going to catch them and who's going to know? Your kids are minors. So you can see there's a problem here of really picking the right person. This takes a lot of thought. Don't just pick anybody, right? Like got to be a responsible person you really trust, that you know is going to do the right thing and step in there and be fiscally responsible. If you don't have somebody in your life, a family member or a friend that can step in and do that, you have other options. You can have a trust company, you can have a bank. There's something in between in California called a professional fiduciary. They're professional trustees. This is what they do for a living. You can meet with them now. You can interview them. You can make sure they get to know you and what you would want. And so, again, the important thing is we have somebody in place that you trust that can do this for you. And I'm just going to throw out one more thing here about international trustees, because I've had lately a lot of clients come in where they want to name someone who's not a U.S. citizen or a resident to be trustee of their trust. This is a huge problem. So that is something that we absolutely have to talk about. It's a huge tax consequence. They cannot be trustee of your U.S. trust. And so we have to talk about what kind of resident or U.S. citizen we can place in that role. You can see there's lots of consequences in the United States when we're trying to name people in other places to control the assets in the United States. And this is one of the big ones. It really has a huge negative effect on a trust. You just can't do it. And so we need to talk about that. And same problem you see with the guardianship being of someone in a foreign country. So something we'll have to talk about, and that's in those circumstances, sometimes it gets hard because all the family members are international. So we really have to put some very curtailed language in our trusts in regards to who it's going to be. And maybe there's an advisor that's, going to be in a different country that they maybe have to consult with, but there's going to be some way that we can come to a happy medium of who you're naming as a trustee. Just really important to pick the right person again, but it's up to us to tell you the consequences of what you choose. So we'll talk about that when we meet with you for that consultation.
Yeah, and Tasha, I'm really glad you talked about clients with foreign connections, because 2 out of every 5 Californians were not born in the United States. Mm-hmm. So that's 16 million people that are in California were not born in the United States. So this does come up quite frequently. And unfortunately, many lawyers, even many trust lawyers, many lawyers that do living trusts who are not experts, just don't know. And they're like, oh, okay, well, we'll do whatever you want. And then it causes a lot of problem and a lot of grief. So that's why, and this is one area, by the way, you absolutely should hire an expert, because the difference between an expert and someone who is not an expert, it's really easy to look and see if something is correct, right? The names are correct. This is who my trustee is, but it takes an expert to know if something is wrong. And so if somebody names a trustee who's in a foreign country, that does create a huge amount of problems. Once that person becomes trustee, your trust becomes what is called a foreign trust under the Internal Revenue Code, and that is not a good thing. So we want to make sure that to keep you guys out of trouble and keep your loved ones out of trouble.
Yeah, absolutely. And then how your children inherit, right, that once if you both passed away is really important. That's because inheriting money is risky. And we say that because it just, 50% of people out there, when they inherit, they just blow the money. I don't think 18 is probably the best age for them to have full control over the assets and all of the money. I mean, I don't know how everyone out there feels about it, but I want to make sure my kids, don't feel entitled and that they're going to have to work to go to college and continue on. And they're certainly not going to be able to control any of this money at any point soon. So yeah, a lot of it has to do with age. Okay, so really focusing and talking to your attorneys about what age is going to be appropriate to really allow them to start controlling that money. Okay, because it's not usually 18. Okay, it's typically much higher. We have somebody else controlling it for a long period of time. You can see here we have the spendthrifts that just like to spend the money, but like we said, the age is just so important. And I know you don't know. I know that I don't. My kids are, they're 7 and 10 and 12, and how do I know what they're going to be like when things change in their life and when they're 18 or 25? Like, I don't know. So the best I can do is just kind of evaluate how I feel about them now and what would be an appropriate age. I'm seeing on average 27, 30, believe it or not, right? Kind of getting through the education and I'm waiting on that. But it's really important to protect those assets from themselves, absolutely, also from third parties, right? So if they have a lot of debt, creditors, if there's things going on in their life, if they in particular are on public benefits, whatever it might be, we have to make sure we kind of lock that up and make sure we have someone else controlling that. We do that through something called a continuing trust. And so essentially in your documents, it would say that, my child, I have 3 kids, they each get a third, a third, a third, and they get their third into these little boxes, these little continuing trust, and they don't get to control them. If they're pre-set up in my trust, somebody else is going to control them until they're 27. They can distribute for their education, for their maintenance, for their support. But sure enough, man, if my kids are 27 and there's some bad stuff going on in their life, if they're going through a divorce or they've got terrible things going on, the great thing about these kind of trusts is they don't have to step forward. They don't have to step forward at 27 and start controlling it. They might want the asset protection. And so they're just going to never do that. If they don't control it, nobody gets to that locked box. So it gives them a lot of decisions, going a lot of protection, flexibility, and ultimately I might be able to protect those assets forever, having these continuing trusts. What is the opposite of that? Saying in your trust, it goes outright. That's the opposite, right? So it just goes to them. Cut them a check. Now everybody can get to it. They get to it, but so does everybody else.
Yeah, and a wise lawyer once said, if you love someone, you'll never leave them anything. If you love someone, you'll never leave them anything. Mm-hmm. What that means is you don't stuff the inheritance in the pockets of the person who's getting the inheritance, because a lot of times they end up losing it. So even if they're responsible, they end up, losing half of it or losing all of it.
Yeah. It's just, you've worked hard for it. You want to make sure it lasts for them, and got to put a lot of thought into how they're inheriting. So these continuing trusts are really important. And now in particular for these clients, they have a child with special needs. And, anytime we have a child with special needs and someone we can anticipate might be on public benefits or they're disabled, and the important thing is that they are probably qualified or will be qualified for outside benefits like SSI or Medi-Cal. And we want to make sure we maintain those because we can't get those any other way. And so for this child, that continuing trust we're setting up is called a special needs trust. It means that, well, they're never going to get to control it. They're going to have a different trustee and they're going to distribute for things the government does not give them money for. And so again, making sure they have a really good quality of life, supplementing what the government's giving them, but ultimately going to make sure that that lasts. Again, it's already protected from all those outside influences. Anything going on in their life, we set them up appropriately there. So really important to think about that. What's going on with your child? Talk to me about, are they a child with special needs? Do they have anything going on in their life where this could possibly lead to public benefits? Are they not going to be able to hold a job? Are they not going to be able to go to college? What are we looking at in the future? And then set them up appropriately and make sure that however they're inheriting, we've done the best we can to set them up to be successful and to take care of them. All right. Some of the other considerations when we're drafting a trust and meeting with clients have to do with a lot of tax planning. Okay. So the first of those is protecting Prop 13. And so if you don't know, Prop 13 allows you to pass on your low property tax base to your children, right? And so this is something that currently on the ballot, you'll see it on there. That's not in regards to your residence, your home. That's talking about commercial property. Although you see a lot of the news talking about how that's the first big attack, right, on Prop 13. And so it's something to consider in California. This was a huge advantage. It meant that when people passed away, of course you see it like in the Bay Area, LA, the values of properties were just significantly, they just were going so high, and it would have been impossible for people to inherit that home and pay that new high property tax base, right? When originally the parents might have been paying $600 a year, and now they're having to pay $12,000 a year, right, if they were to be reassessed. And so it's just this, when Prop 13 came in, it allowed families to stay in the home. So there's a lot of exemptions, not automatic thing. Not everybody gets it, and you have to actually, say what the relationship is that allows you to carry it forward. Being a child is one of those exemptions. It gets to go to the spouse that way and not be reassessed. But it's a really important element of what we do in planning, making sure the trust and what we put in the trust is going to protect that Prop 13. Reducing capital gains taxes, and just kind of a basic lesson in what happens with you and your joint property, your community property you own with your spouse. Everything that you have, your stock or your real property, it has a basis in it that you're paying taxes on. And what happens is if it's rising in value over your lifetime, if one spouse passes away, you're going to get what's called a step up in basis to those date of death values. Okay. So at that point in time, it does give that spouse a couple opportunities because they could sell some property. And if there's been a lot of gain in that property, they can avoid any kind of capital gains taxes at that point. all right, if they hold on to the property and it continues to rise and rise in value over their lifetime, well, when they pass away, the children, they get something called a second step up in basis to those date of death values. So if they were to liquidize and sell the property, they're also going to avoid capital gains taxes. And we are always talking about this with our clients because you know, how you have things titled, how you currently hold title is going to matter. It's going to matter throughout your lifetime, the decisions you're making, and how are you going to pay for long-term care? Do you think you're going to have to sell a house? Maybe there's a better way because we're looking at a ton of capital gains taxes. So this is something that just, again, working with the right attorneys and expert attorneys, you're really going to get a good feel for. We're watching out for that. Okay, and you should be too, but you've got to rely on the right attorneys to make sure this is being taken care of and, you know, in your plan and making sure we're not blowing anything, but also just throughout your lifetime that these decisions, you're going back to an attorney to ask them for advice, right, to make good decisions. I want to mention, we don't have a slide for it, but one of the major tax planning decisions has to do with the death tax. And the death tax, also known as the federal estate tax, is that the federal government gives you a certain amount of money you get to die with tax-free, okay? And anything and above that amount of money, you're going to pay like 40% to the federal government. Right now, every one of us individually have a huge amount of money we get to die with tax-free. It's over 11.5 million per person. As a married couple, you get 2 of those, right? So that's a lot of money. Not too many people are worried right now about paying the federal death tax. Although that changes over time, right? It's not that long ago that everybody was worried about paying the death tax because it was only 600,000 you were allowed to die with tax-free. So that's something that you need to keep your eye out for because the structures we place into a trust have a lot to do with tax planning. And if people could be subject to that death tax, we're going to do a lot more structuring in these trusts to deal with it. Versus if you're not subject to it, this is why you gotta, don't put that trust in a drawer, right? Take it out every 3 years. Be sure you're talking with attorneys and making sure it's still working. And because depending on who's in office, okay, and what the new laws are going to be, that could change drastically. And we'll have to recreate people's trust to address it.
It's also important to note that there are state death taxes. So Massachusetts has a state death tax. Oregon has a state death tax. And what that means is if you have more than $1 million in assets in Oregon and you die a resident of Oregon or you own property in Oregon, anything over $1 million is taxed at up to 16%. So even though there may not be a federal death tax, for many of our clients who own property in other states or end up moving to another state, there is a state death tax. So that's something to be mindful of when you own property in a state, and we're in California. So if you own a property in a state other than California or move to a state other than California, it's something very important to consider.
Yeah, because California currently does not have a death or an inheritance tax. Not that that couldn't be changed by everyone voting it in, but it currently, and since like the late 1970s, we got rid of our death tax. So people in California right now, there's your one tax advantage of living here. Who knows in the future if that's gonna be taken away, but yeah, no current death tax in California. But again, we consider wherever you hold property, we're gonna talk about that kind of planning because boy, it's really important. So with these trusts that we're creating, the more modern way of estate planning is that we have to have a way to change things. Because as you can see, the tax laws are constantly changing. Probate code is changing. There's so many things. And if you became incapacitated and couldn't get in, right, to make these changes to your documents to move with the tax laws, we have to have a way to do that without going to court. So in modern day estate planning, what we have in all of our documents is something called a trust protector. The trust protector is typically the firm that you're working for. It's us. Cunningham Legal sits in our documents as the protector of the trust. We are not a trustee. We're not watching your trustees. We don't have a duty to monitor anything going on. But it means they have someone to come to instead of going to court, who can make some changes, not all changes, but we can clear up ambiguities. We can appoint a trustee if we've run out of trustees and nobody can act. Or if now someone's not a resident or citizen of the United States and we need to appoint now a US citizen, right? All those things, instead of going to court to handle that, the trust protector can stand in that role and they can go ahead and just sign a piece of paper and make it happen. So you can see it's just a huge benefit. And when you have minors and they're inheriting into these continuing trusts, who knows what's going to be happening in their lives, right? We might have to make a change to that, make a change to their trust, put a different trustee in there. Maybe the trustee you chose was a parent and they've passed away. Again, all of these considerations, our lives are constantly changing. Our assets are changing and the laws are changing. You have to have a mechanism to deal with it and not have to constantly go to court to do it. So really important to have a trust protector in your documents. I wanted to talk a little bit about our next slide here about blended families, because blended families is really common. And when I'm talking about a blended family, I mean his kids, her kids, maybe their kids. Even with my younger families, you know, some have divorced and remarried and they each have their own children. And you can imagine this is something that can be very messy if you don't have a plan. We've got a lot of conflicting interests there with the spouse, and you know, how do we provide for them, and how do we make sure at the end of it all, if that spouse passed away, it goes to my own children. Okay, so control and balance, so important. It's one of the most difficult kind of planning structures we can do to really work out, what do you want? What's your intent? How do you want to make sure this, you know, is fair in the long run, and that your own children are going to get your assets at some point? So I just wanted to make kind of a note on this when it comes to blended families, because I'm finding a lot of my young families are blended. I don't know, Jim, with you, if you have anything else to give kind of advice. I have an entire seminar we've done on blended families. That's how important it is.
You know, I got to tell you, I think that, you know, as lawyers, we have a knowledge of the law, and we forget that normal people who aren't lawyers just don't even know how complex it can be. And, you know, the law is written to apply to everyone equally, right? So there are no carve outs for individuals. There are no, you know, no one gets special treatment. A judge is going to apply the law and apply it equally to all people involved. And in many instances, who ends up with the money, right? Or who ends up with control is not what the people wanted, right? It's not what the parents wanted. And it's a completely different result. It's designed to be fair, but many times it isn't. And here's the beauty about estate planning. You know, there are many countries where you can't choose who gets your who gets what you've taken a lifetime to create. France has something called the usufruct, which is the usum of the fructum, which is, you know, a Latin phrase, which means that the kids get some of the inheritance, and there's no way around it. So oftentimes the surviving spouse has to buy the kids out. And so in the United States, we have the freedom, if it's done properly, right? We have the freedom to create an estate plan and leave the property exactly how we want it. And for blended families, and again, you know, if this is not amateur hour, especially when it comes to blended families, you absolutely have to hire an expert lawyer on this who understands all of the, you know, understands the law and all the possibilities that come with a blended family.
Right. Yeah. And a lot of it has to do with what's called the characterization of your assets. That's in general, like how you hold property and title, because it gives different rights. So there's something called community property. And that is once you were married, right? Once you became married, any property during that time period that you're married, any debt acquired, well, that's marital community debt and assets. So in California, community property state, they have a right to that, okay? And then there's something called separate property, and it could be that you acquired a property through inheritance. That's your separate property, even during marriage. Something acquired prior to marriage, all right, that, you know, you already had a home and you had your, it could be your retirement prior to marriage. And once you get married, a whole new chain occurs. And so it really matters how these assets are titled and whether you've commingled them. Did you throw it all together? Like, do we know what's community property and what's separate property? How do we control that? Super important in blended families, especially if you want to make sure that something you inherited from a parent is getting to your children and not going to your husband's children, right? And so the characterization of these properties is just really important. And title has a lot to do with that. You know, how do you hold title to your home currently if you don't have a trust? This is a big deal. I mean, this can really cause some headaches down the line. Because I think when people buy a home and they're talking, you know, with the agent and they're saying, well, how do you want to hold title? I don't know. How should I hold title? And they're like, well, I can't tell you, but most people put joint tenancy. Okay, like that's a problem. Okay, to just hold something in joint tenancy, it's got to be a little bit different than that to make it work for tax purposes. And so we, you know, you just got to look into, you got to be working with attorneys, and we got to make sure that is titled properly before you put it into the trust. All right, because there's a lot of tax advantages to have it titled a certain way. But again, how have you titled that property? Really, really important going forward, that you know what you chose and what the circumstances are by doing that. Okay, so you have a trust, right? Our clients have a trust, taking really good care of them during incapacity. We have the guardianships all kind of set up for them. We know their kids are inheriting into these continuing trusts, all these backup provisions with a trust protector, we're ready to go. That's not a complete plan. You can't just have a trust. So let's talk about what is a complete plan for them. So one, it's not listed here, but you always have a will, okay? So this is very different, because if you just had a will, if my clients just had a will in this circumstance, it does not avoid probate. So don't think that you just writing up a will that says everything goes to my children is somehow avoiding probate. It absolutely is not. It will go through a full court proceeding to prove it's a valid will, to prove it's the last will, all right? And has no control during incapacity. That's just not, completely not helpful. But once you create a trust, the trust is what says where everything goes, who's going to control it, and how are we going to distribute it. Now you have a will, but it's called a pour over will, and it says, I leave everything to that absolutely amazing trust over there, and it's going to do great things for me, right? We don't want anything ever ending up in probate and putting a will through a probate procedure. So it always points to the trust, and it really doesn't say where anything goes. It just goes into that trust where I have this great plan. So you will have a will. It's called a pour over will. In addition to that, you have what's called a durable power of attorney. This is a power document, just like your trust. What's the difference between the two? A trust controls all of your assets titled in your trust, which should be about everything. Your bank accounts, brokerage accounts, your home, any real property. That should all be titled in the trust. So what really is sitting outside over here? Your retirement, right? That might be outside there, life insurance policies. If anything is sitting outside of the trust, we control it through the durable power of attorney. Okay, so that's controlling finances that are sitting outside the trust. Those are your two power documents during incapacity. They control different things. Don't use the wrong one. So for the durable power of attorney, it's probably going to be the same people you named as the trustees to be your backups, right? Those are going to be the same people controlling all your finances, wherever they are. Whether it's the will, the trust, or the durable power of attorney, we're talking about money, it's the same people. Then you have your healthcare documents that are essential. So you have an advanced healthcare directive, and that's your document where you've named the people you want to make those ultimate decisions of your care. And it could be, you know, a very quick decision, right? Something's happened to you. It could be to stop your life, right? And that DNR kind of thing. They make that ultimate choice. Or it could be you're aging and you're 90, right? Let's hope for all. And it could be everyday decisions for years and years while you're in a long-term care facility, right? So you have to think of it both ways. We are hoping that we live long lives, and that at some point you're going to update your trust and it's going to be your kids. I mean, that's ideally what we all want. So you can imagine there's going to be changes you're going to make to these over your lifetime. But initially, your kids can't make that decision for you. They're minors. So you got to choose the right people to step in and be your healthcare decision makers. The HIPAA is medical privacy. So people having access to your medical information, making doctor's appointments for you, releasing that information to, very important. California's is very particular and is only valid if it's 14-point font. And if you don't know what that is, it's just a little bit bigger than 12. So very strange things like that in California, but you got to make sure it's a valid HIPAA. And the POST form, and that is an acronym. It stands for Physician's Order for Life Sustaining Treatment. That is the new DNR. Okay, still a bright form, front and back. But the difference is it's signed by your doctor, it's signed by your physician, and they should be the ones talking you through those big decisions, right? It's not us as attorneys, we're not doctors. And so although we set the right people up that we talk about, that are going to be making decisions for you, if you have filled out a DNR, it has to be signed by that physician. And it's really important if you are of ill health right now and they've suggested that, these are things that you really need to take care of. A living will is something we do prepare that coincides with that POLST form. It's something that just gives a little bit of guidance to our loved ones, where we're saying essentially the same thing. All hope is lost for me. Nothing can be done. You can go ahead and let me go. So it's giving just a little bit of guidance to those people that are going to have a really hard choice to make. Okay.
You know,
so
if I can just say one thing on this, my mother-in-law passed away in March after a very long battle with Alzheimer's disease. So she was in and out of the hospital, and going to the hospital before COVID was possible to go see her. But something that we probably all know now is if anyone goes to the hospital, your family members, whether you have COVID or not, they're not allowed in the hospital. So it makes it far more difficult to navigate this, to navigate the healthcare aspects of somebody who's in the hospital if you don't have these documents. So it's very, very important that you have these. And I know for our clients who have them, and because it's happened where people have gone to the hospital, whether it's COVID, and we've had some clients with COVID and some have gone to the hospital without it, it's very important to have these documents updated, make sure the right people are on there, make sure that your medical providers have them. And many times clients will ask us, hey, can you email this? You know, I'm standing outside of the hospital. Can you email the document to the physician? And we certainly will do that for our clients. But it's very important to pay attention to this because we're going to be in this COVID thing for quite a while. And we're just not going to be able to go visit our loved ones when they're in the hospital. So very important to pay attention to.
Mm-hmm. Yeah, good point. All right, what about planning for assets outside your trust? So we've talked a lot about, boy, that was a lot of documents we just covered that are really important. But I just told you there was some of your things sitting outside of a trust. So we've got a plan for those. And one of the big ones is your retirement plan. So if you're young, it's probably not called an IRA yet. You probably have a 401k. But I want to talk a little bit about your qualified plan, whether it's a 401k, 403b, a TSA. What I'm not talking about is a pension. I'm guessing maybe not too many people out there have pensions anymore. And so I'd be surprised, maybe, I don't know if anyone's on the line and has one, but those pensions you leave to your spouse, there's no way to carry those forward usually to the children. But with the 401ks and the other qualified plans, you get to decide where those go. And those tend to be, especially for my young families, their largest asset. Yeah, and it's sitting outside your trust. How are we going to control that, right, if you pass away? And one, it's really important for you to understand the laws regarding your retirement plans and what happens when you leave it on to someone else. And how you leave your retirement plans or 401k, you've listed a beneficiary on that form. You somehow, I'm sure your employer has made you list someone, and typically it's spouse first. All right, not always with blended families. We can talk about that, but typically it could be spouse first. It's beneficial for them, and they can grow it for their lifetime. There's a lot of benefits involved in it passing to a spouse. But we've had some huge, significant change in legislation for the first time in decades in January of 2020 in regards to assets passing on to your children. So I want to talk about, the Secure Act is what it's called. The Secure Act, again, was passed in January of 2020. It was in the news all over because they were going back and forth when they put it into Congress, and it wasn't passing. Okay, it did not pass the fast way. And then what happened was President Trump grabbed it and just put it into a spending bill, and like that, all new regulations really quickly. And so it was a game changer and really great benefits for us, right? In our 401k planning and for businesses, and we get a longer time to wait to take it out. All these, it's an acronym that means setting every community up for retirement enhancement. Yes, like that's what it's meant to do for us. The downside of it was, again, the effect on our loved ones when they inherit. So it used to be that I could name my kids, on my beneficiary designation form, and if it went to my children, they could what's called stretch it out for their lifetime, meaning they could take a little bit at a time, right? Depending on their age for the rest of their lives. And if there's something left, they get to say where that goes, and that person stretches it out, and that person so you get a lot of benefit to not having to pay it all in tax all at once, which is huge. Because if you have a large retirement plan, if it's whatever it is, 400,000, $1 million, if that all pays out all at once, you're going to pay income tax on that, and you're going to lose about half. That's huge. And so it was a huge benefit to allow whoever we're leaving it to have this stretch out over their lifetime to kind of take the hit a little bit at a time when it came to income tax. What the Secure Act did is it said, no, none of that anymore. You can't do that stretch out. It's now a mandatory 10-year payout. So if they inherit it, they've got 10 years, no mandatory distributions. You don't have to take it year 1 or year 2 or year 3. But whatever you take by year 10, it's all coming out and paying out, okay? What does that mean? Okay, well, first of all, we've lost complete control. Now we have a ton of money being paid out to minor children. Again, we go back to that guardianship of the estate, all kinds of problems, that we can't control it from their own hands, let alone from creditors, people that are out there. And 2, we have this huge income tax problem of it all paying out and losing most of it in taxes. So now there are exceptions to this rule of this 10-year payout. One of those is if they're a minor child. So they do get to wait till they're 18 for that 10-year to start accruing. Okay, if they go to college, they get longer. They get to wait a little bit longer and then tack on the 10 years. But let's say you've named, spouse first and then kids like mine, the third, and my spouse and I, we pass away. And my kids are minors. So they wait till they're 18. You know what happens at 18? They have full access to that IRA. If they want to, they could cash the whole thing out. Can you believe that? There's nothing controlling that. I don't want that. Oh my goodness, I don't want them cashing that out. That's a terrible plan. So we just have a huge problem with considering our retirement plans and what are we going to do to control it? What are kind of our options? So what our firm does a lot of planning for, especially for our young families where they have minor children, is the federal government has told us, the IRS has approved for us to create a trust just for retirement plans. We have to keep them separate, believe it or not. We can't lump it into the revocable living trust that we created, taking care of all that great thing. We have to deal with it separately in its own separate trust, and they've allowed us to do that. So for a lot of our clients, there can be a huge advantage to doing that depending on the circumstances of the child, especially for someone who is disabled or special needs, because they get to stretch it out for a lifetime. They're an exception, right? But if you leave a retirement plan straight to that person without using the separate trust, it'll kick them off their benefits. All right, it's going to have a really detrimental effect to them. So what they've approved through a private letter ruling is something called an IRA Legacy Trust. It's a separate trust just for your retirement plans. And I want to give you an example of how it could work. Option 1, you've just named, child Tom on that beneficiary designation form. The parents pass away. He inherits a $200,000 IRA. He takes it all out, right? He doesn't know there's going to be a huge tax bill. He buys a bunch of stuff. He parties, whatever he wants to do. And then the money is all gone. And he gets a huge tax bill for $100,000. And what have we done to Tom? All right, so this is a huge problem when thinking about our children and inheriting these. What is the solution to that, and how do we kind of protect that IRA for minors? Is that we create a trust, and on that beneficiary designation form, it might say spouse first, but listed second, it says my IRA Legacy Trust. So that if my spouse and I pass away, it's going to drop into a controlled environment, be completely protected from outside, right, creditors, predators, divorce. And it's going to be controlled for them for a long period of time. They're not going to have access to just cash it out. So for $200,000 IRA, it's going to drop into this trust, continue on as a retirement plan for Tom. He can receive distributions as he needs them. So the trustee, who's not Tom, can make distributions for his education if we need to. And at year 10, when it has to pay out, right, whatever that age is going to be, whether Tom went to college or not, at year 10, when it all pays out, it doesn't pay into his hands. It pays into the trust, and the trust continues to invest it and control it for his benefit. So a huge strategy of just, if you have a really large retirement plan and you haven't put any thought into it yet, now's the time, right? Now's the time to really think about this. And there's definitely some circumstances where it's more important than others. So again, those people that are with disabilities or a child with special needs, really, really important.
Yeah, and I got to tell you something. Tasha and I, we have other lawyers reach out to us and say, you know, I've heard you guys talk about, these are other estate planning lawyers. They don't understand this stuff. Very few estate planning lawyers, even expert lawyers, expert estate planning lawyers, truly understand this. And so it's so important to hire the right lawyer, especially if you have an IRA, especially if you have a minor child. Make sure you hire somebody who really does understand this.
Yeah. And a lot of you out there, and you probably have Roths, and even better. Right now, we don't have to worry about the tax problem. Now we're just controlling the asset. That's just a great tool to put into that IRA trust. So you have 3 choices on the beneficiary designation form. You could just name the kids on there. Again, we have no way to control a tax bracket management. A lot of times we move these IRA trusts out of the state of California for income tax purposes. That might be something that's really beneficial. But again, no protection. They get their hands on it. They can do whatever they want. It's just no protection. You can name your living trust. Not that long ago, I keep getting clients in here that I'm looking at their beneficiary designation forms. They have spouse and then my trust. It's not going to work. All right. They do not like that. The IRS does not like that. We're not going to have the opportunity to even get the 10 years if they were able to get that. They're going to make it pay it out in 5. It's even worse. And it's not going to be able to sit in that trust and continue on. So just have to be really careful about who you're naming on that beneficiary designation form. So of course, depending on your circumstances, a lot of times for minors, the best choice is to create this IRA trust. And again, we have some opportunities for tax bracket management if we're worried about taxes, and then we get that protection back. Get to put some terms on how we're going to control that maybe your largest asset. All right, I wanted to talk a little bit about life insurance policies, because that is also something sitting outside your trust. And so back to, everyone buys life insurance for different reasons. Typically when you're a young family, we have income replacement, pay off the mortgage, education costs for our children. I mean, that's kind of the typical reasons why we have term policies. And I know you've invested that money and made sure that every year you're paying that to kind of protect against this, and maybe at some point it could or could not pay out, right? So that also goes by a beneficiary designation form. So you have listed on your life insurance who's going to receive it if something happens to you. Number 1, make sure it doesn't just say spouse, because what if you pass away together? Typically, these life insurance policies are fairly large. If it's a $600,000 policy and you and your spouse pass away together and no one was listed second, that's going to court, right? That's a problem. And so at the very least, you got to name someone secondary on there. And should it be your children? Well, they're minors. Now we have another problem. And so it's just really important to talk with your attorneys about what's the right way to point this. A lot of times, if we have minor children, we make sure the beneficiary is going to be your trust after the spouse, because that life insurance policy can dump into our trust, help with expenses, funeral costs, pay off that debt, pay off that mortgage, and be held for the benefit of the children. But we certainly don't want it dumping into a minor's hands and having to go to court to figure that out. And so it's just really important if you have those policies to have them set up correctly. And you can see as we're going through here, and we're just about done, that it really matters who packs your parachute. And we say that a lot in estate planning because not all attorneys are created equally. Not all trusts are created equally. We review hundreds and hundreds of trusts every year, and the flaws in them are just devastating. I mean, I can't even tell you. So the point is, this guy is not going to survive. That's kind of parachute. I don't know who thought they were packing that. But when you need a parachute to work, right? When you need your trust to work, you better have everything in there you could possibly need, and it's planned appropriately so that everybody's happy and you're going to make sure that it's going to last. So a little bit about Cunningham Legal, if you don't know anything about us, is that we are a firm created by our founder, Jim Cunningham, more than 26 years ago. So Jim's been doing this a really long time. And we are a team of attorneys. It's not just one attorney doing everything. We have just a huge amount of staff. We are based out of Auburn, California, in Northern California. We have 3 offices up here. We have remote offices in San Ramon and some other areas. And then we also have 4 locations down in Southern California with additional attorneys. You can see our attorneys up here. Everybody, we only do this. We're very specialized in this area. A lot of us having, upper degrees. I have what's called an LLM after my name, which is very confusing, but it's a legal master's degree specifically in estate planning and taxation, meaning I went back to law school after already being an attorney and did an extra 3 years just to do this. And then you've got Jim, and Jim is what's called a certified legal specialist with the State Bar of California. And to do that, you have to be practicing for a certain amount of years. You have to take a second bar exam. Can you imagine taking a second bar exam? Way to go, Jim. And you have to get a lot of recommendations to move forward. So it's just an incredible accomplishment, and such talented attorneys within our firm to be working with. And we really do work as a team. We meet on multiple basis, many times a week, to discuss really difficult tax issues and planning and what we have in our documents to make sure they're still working for the changes in the world, right? So really important you're working with the right team. It matters who packs their parachute. A little bit about our estate planning process. We want to meet with you, right? It's a free consultation. We'd love to meet with you. And when we meet, we can talk about what your plan, what the fees would be. But one thing great about estate planning with us is that we are a flat fee-based firm, meaning that we're going to quote you a fee and it's going to take care of everything. We're not going to calculate per minute how long it takes us to do things. And every time you call, charge that to you. I don't like it. You don't like it. It's not fun for anybody. So it's a great value to do that. Many attorneys in this area are charging hourly, and every time a client has a question, they send them a bill. And I can't tell you how many of those people walk away never having a trust because they get so frustrated with the bill that they never end up signing anything. So just really important that, we want to make sure you're taken care of, and we're going to take the time it needs to do that by charging that flat fee and not worrying about how many minutes we talk to you on the phone. You can see that we really believe in education. We're going to bug you a lot. If you're our client, we do a lot of webinars. We send out a lot of information. When there's a law change, you're going to hear from us. And we also have ongoing communication. We like to meet with our clients every 3 years, make sure everything's still working for them. You can see that the value you're receiving from the firm you're working for is just so important to consider. What's going to happen, if I pass away? You're okay. You have a whole team of attorneys taking care of you. So just really important that overall, this is going to happen, right? You're going to have a successful plan, and that you're going to be taken care of. People know who to call. And so with that, I went a little over on time, but pretty close. I want to thank you for joining us. And again, what we're doing is we're thankful you're here. What we do is offer a free, no obligation consultation to meet with me. And we're going to kind of get into it, talk about what your wishes are. We're going to ask you to fill out a diagnostic, we call it, where it's asking you to list for us, what are your assets? Who are your loved ones? And then we're going to review that together and come up in that planning consultation with what's a good plan for you and what kind of things do we need to think about as we kind of get to know each other. All you have to do, right, is call into Cunningham Legal and make an appointment. We try to make it really easy.
Oh.
And then show up. Yeah. So give us a call, and you will receive an email after this seminar and this webinar, and it will give you some contact information to go ahead and press a link and talk to someone, and so you can go ahead and set up that appointment. And again, have an open mind. If you already have a trust, bring it. I'm going to want to look at it. It's really important. And if you started off with something, printed something off online, good chances it's not working. You probably didn't fund it. And so we've got some serious issues we have to deal with, but I'm going to have to look at it. So I'm going to want to see your documents, that diagnostic, and really important that we do some planning and get this in place. Do not procrastinate any longer. I hope that you see that. Boy, young families, you can see just how important it is to not wait. Just set up yourselves. I mean, I'm sure you have spent so much money in sports. I know I have. Sports and activities and music lessons and paying that life insurance every month, right? And for some reason, you're putting off the biggest thing that you could possibly do to protect your family. Don't do that. I mean, I don't know how many times I have to say that and how many people I see here over and over again that are going through this. So get it done right. Make sure that, it's properly been created and doing what you need it to do. And with that, I'm going to go ahead and take any questions. If anybody has any, go ahead and post in that question section.
Yeah, and while you're typing in your question, we do have additional upcoming webinars. We do have one at the end of the month, which is an economic update from an economist at John Hancock, and that's going to be a really great update where they're going to go over the current economic conditions at the end of July. And these are always really popular. We've done these with other institutions before, but they're very informative. I think the last one we had 200 people on the webinar, so they're just very, very popular. Clients really, really like them. So we'll give it a couple more minutes on Q&A, and going once, going twice. I think everyone wants to get to dinner.
Wonderful. Okay. Well, we
then
really appreciate you joining us, and look forward to meeting with you.
All right. Thanks for attending today.
All right. Thank you.